Welcome to The Edge Case by DSK Legal, where we will discuss privacy law concepts the way they actually play out in practice and not how they are debated on panels. For this episode, we have Siddharth Suresh and I am Abhishek Mitra. We are both technology lawyers and we will be talking about the real challenges that companies face when deploying a privacy program. Over to you, Siddharth.
Thanks, Abhishek. I work closely with companies on data protection and compliance, often at the point where they're trying to decide whether a particular data set even falls under privacy law at all. The topic we have chosen for today's discussion is data identifiability and how a misunderstanding on the subject can lead to major non compliance under privacy law.
So let's get into it. The DPDP Act regulates the collection and use of personal data and defines it as any data about an individual who is identifiable by or in relation to such data.
Now, while details like name, address, Aadhaar, passport are obviously personal data as they point to a specific individual, what about disparate information collected through logs and clicks, which on their own don't make any sense? Would collecting or otherwise dealing in such information be regulated by privacy law? And if yes, can you imagine the gamut of information which can fall within the purview of privacy law?
Before we get into examples, let's set the frame. Privacy law does not ask, do you know who this person is? It asks, can a person be identified, singled out, or linked directly or indirectly using means that are reasonably likely? And two things follow from that. First, the data doesn't need to name you. Second, the business doesn't need to intend to identify you. The only thing that matters is whether, in context, the data can reasonably be linked back to an individual.
Wait, but by that logic, almost everything becomes personal data. Isn't that an overreach?
Not really. And this is where the misunderstanding usually starts. The test isn't theoretical identifiability, it's practical contextual identifiability. If your own systems, teams, or vendors could re identify the individual without unreasonable effort, then you are squarely in privacy law territory. That's the test.
Now, as an example, let's look at the health insurance sector, where a data set of insurance claims shows age brackets, rare diagnosis, city, and hospital visited in a specific week. Now, in a large city, inferences from the data set may still be ambiguous, but in a tier 2 city or small town, it could point to exactly one person. So, the same data set can have different outcomes because context changes everything. That's the quiet but radical shift under privacy law.
Let me break that down a bit. Direct identifiers are obvious: name, email, phone number, Aadhaar, passport, the usual suspects. Link even one of those to a data set, and there's no argument to be had. Indirect identifiers. Now that's where companies get into trouble consistently.
Exactly. Indirect identifiers are data points that don't identify you on their own, but do once context is added.
Let me walk through three situations, each one drawn directly from how regulators approach identifiability. And starting with aggregation, because this is where most businesses feel the most comfortable and most protected. Take any digital platform, fintech, logistics, a marketplace, infrastructure, running analytics on its own data. A dashboard shows usage numbers by city, broken down by time window, filtered by a specific feature or event. There are no user IDs, no names, no profiles. Everything is charts, percentages, and counts.
And at that point, most businesses are very comfortable saying, that's anonymized. This is not personal data, it's aggregated.
Exactly. And that's where it gets interesting. Now, watch what happens when the analytics team starts refining that data. They look at usage between midnight and 2 a.m. They filter for a specific, rarely used feature, and they narrow it down to one city. And suddenly, the chart resolves to a single data point. Not a name, not an ID, just one. Something significant just happened. The data is still aggregated, but the group has collapsed.
This is the key point. You still don't know who the person is, but you now know that there is only one person behind that data. That's identifiability without identity. And regulators are very clear on this. Aggregation protects privacy only so long as it actually hides individuals. The moment aggregation leaves you with a group of one or a group that always behaves like one, the protection is gone.
And this is precisely why regulators say anonymization is not a question of technique, it's about outcome.
If a dataset allows a person to be singled out, even without a name, privacy law is triggered. And that's uncomfortable for businesses because nobody intended to identify anyone. But intent doesn't matter here, capability does.
Let's take this a bit further. Picture a system that logs activity over time. Each event is anonymous. There are no persistent IDs, no user profiles, and no obvious identifiers. Taken individually, each record is just noise. So the typical business position is we are not tracking users, these are just independent events.
But then over time, patterns emerge. The same sequence repeats, the same behavior recurs, the same unknown actor keeps appearing in that data. You still cannot say who the person is, but you can say this is the same person again.
That ability, being able to recognize the same individual across multiple interactions, is what is called linkability. And linkability alone, without a name, is enough to bring data within the scope of privacy law. This is the point where identity becomes irrelevant. Without ever knowing someone's name, you can still track continuity, observe behavior, and make decisions about the same person over time. All of that is treated as identifiability.
And this is very important for technical teams. Engineers understand persistence instinctively, the state, the recurrence, the patterns. What they often don't realize is that persistence is a form of identification. So the moment your system can say, I have seen this person before, you have crossed from anonymous data into personal data, even if you never learn their name.
Let's look at another nuanced example where the identifiability question gets missed very often. A company processes a dataset that contains no names, contains no direct identifiers, and appears meaningless on its own. The company on its own genuinely cannot identify a single person from it. So the conclusion they draw is this isn't personal data. We can't identify the individual.
But the law doesn't stop there. The question is not only whether you can identify the person, the question is whether someone can. That someone can be a vendor, a platform partner, another entity in the ecosystem. If that other party holds additional information that can realistically be combined with this data set, identifiability exists.
And regulators are not ambiguous on this. It doesn't matter that the identifying piece sits somewhere else. If reattribution is reasonably possible, the data is still personal data. And this is exactly where identity and identifiability fully separate. Identity says, do I know who this is? Identifiability says, could someone reasonably find out? Those are completely different questions. And the law is built around the second one, not the first.
And this is why we don't have the key is not a defense. If you know the key exists and you know it can be used, privacy law still applies.
So, stepping back for a moment, all three of these examples are really telling the same story. You don't need names, IDs, or profiles. Identifiability can arise because aggregation collapses, patterns persist, or the necessary context to make someone identifiable exists elsewhere in the chain. Privacy law isn't built around who someone is. It's built around whether a human being can be singled out from the crowd.
And once a person can be singled out, linked, or inferred, even indirectly, the data is about that person. That's the threshold.
And the reason this matters practically is because once data crosses into personal data, you need a lawful basis to collect and process that data. You need safeguards. And you need to build mechanisms that let individuals actually exercise their rights over that data. Get identifiability wrong, and everything downstream, your consent framework, your data mapping, your vendor contracts, is built on a false premise.
And here's the key point: privacy law enforcement won't turn on what you believed, it will turn on what you can defend. It's about being able to explain, justify, and stand behind how you classify and handle data, particularly when you are under scrutiny. If asked, Could you identify the person if needed? And if the honest answer is yes, then calling the data non personal won't save you.
So the real exposure isn't from processing personal data. It's processing it while insisting that it's not personal data. And that's a good place to pause. We have covered what identifiability actually means and why so many businesses get it wrong. But knowing that you have a problem is only the half of it. The harder question is, what do you actually do about it? In the next episode, Siddharth and I will get into anonymization and pseudonymization, the tools businesses reach for when they want to de-risk, and why those tools are far more fragile than most people realize. See you there.